Everyone, this is the ESOP guy, and we are on a journey to an ESOP. So glad you could join us today, and wanted to kind of make sure that you, as you tune in, if it's your first time, I wanted to say thank you for listening and welcome to our podcast. If you have an interest in this podcast, please go to our website at journeytoanesop.com. And what we do from time to time is we'll do different topics. And today we get to do an interview, I think, on a very important topic, which is the Department of Labor investigating ESOPs and what that's all about. So at times, the Department of Labor will investigate an ESOP-owned company, and they're looking for specific issues or problems within how the ESOP was set up, and they want to make sure that they've protected, as a Department of Labor, protected the employees from any potential problems that got maybe created with the ESOP. So going into what we're going to go into today is what is the ins and outs of a Department of Labor investigation. And to do that, I thought it would be a great idea to have Wayne Isaacks back on the podcast. This is his second time as part of our podcast. Wayne is the principal of Isaacks and Associates. He is an existing ESOP trustee. He's been working on ESOPs for a very long time. He's not only an attorney, but he's also a CPA, and he resides out of Houston, Texas. So with all that, I just want to say, Wayne, welcome back to our podcast.
Sure. Thanks for having me, Phil.
Great.
Always happy to help where I can and help educate people on the ESOP, the ESOP journey.
Awesome. So for the audience listening, some of them are completely brand new to ESOPs, and so when we even say Department of Labor, they're probably saying, "Hey, what's that all about?" And so really, an ESOP is a retirement benefit plan. It's a qualified benefit plan, so it's going to be and it's going to have to comply under the Department of Labor's guidelines, and specifically because it's a retirement plan, and the Department of Labor really is there to protect the employees within the scope of those types of retirement plans. So when you think about all that, some people that are thinking about doing an ESOP might be thinking, "Hey, is this for me, or is it not for me because of having to deal with the Department of Labor, or potentially having to deal with the Department of Labor?" So some of what Wayne and I want to talk about today is just lay that out a little bit and give some background to that. So from your perspective, Wayne, when the Department of Labor is looking at an ESOP to potentially investigate it, what are actually they looking for?
Well, first we got to see, like, one thing to keep in mind is, as you said, the ESOPs as a pension plan, all pension plans their qualified plans are subject to the Department of Labor rules in the Employee Retirement Income Security Act of 1974 and the regulations the DOL makes for the governance of ESOPs, for things ESOPs can do and couldn't do. The Department of Labor is also the watchdog for ESOPs, and so they have a department, we'll call it EBSA is what they call it, and they are charged with, I'll use the word policing, but ESOPs, they investigate ESOPs if there's a reason. Sometimes they'll investigate just as a random investigation to train people. Sometimes they'll start an investigation because there was a complaint by a participant. And as I said, they'll select ESOPs for investigation. Now, an investigation is what they call it. An IRS, when they look at something, they call it an audit, an IRS examination or an audit. The Department of Labor does investigations, and they're divided into multiple regions. There's a region in Texas, headquartered in Dallas. There's a region in New York. They're all over there's several regions in the country, and the regional officers of the DOL of EBSA select plans for examination, and when they do it, they send a letter saying you've been selected for examination, and we want a lot of information about your ESOP. Invariably, they always look at the ESOP transaction, the original transaction or a recent transaction. And they pick that up and ask for all the documents, all the records, and then they'll want to interview the people who were involved in that. It would be the sellers, the trustee, the company executives, and then they'll look at the ESOP transactional documents. They also want to look at the valuation. And so a major element that they always look at is the valuation and the terms of the ESOP transaction, because they want to be sure that there hasn't been a violation of the ERISA rule that an ESOP cannot pay more than adequate consideration for the price of the stock, and that the terms have to be commercially reasonable and fair to the ESOP. So they'll look at the term of the notes. There's special rules relating to ESOP notes. They'll look at the interest rate. They'll look at the payout terms. But mostly they're looking at the price and how we determined that the price was fair. So they look into the valuation. And in many cases, they will do it in their investigation. Some people think it's arbitrary. Some people think it's predatory because they don't like what the DOL will say sometimes. But after their investigation, the DOL will not always, but often enough say, okay, you valued the stock too high, or your interest rate was too high, or some other element of the ESOP transaction wasn't fair to the ESOP. What they look for is not just the absolute price, but they look at how the valuation was conducted. Was it conducted in accordance with sound valuation principles? They may have a difference of opinion of that compared to our appraisers that we use. And they will also look at how the transaction was negotiated, and were the parties, the trustee side, the buy side, were they independent? Were they truly independent? That is, they hadn't worked for the company before. They're not beholden to the company. That the appraisers were qualified, and that the trustee conducted a real, robust, and honest negotiation of the ESOP price. And did the trustee and the financial advisor investigate the financial circumstances of the company, its outlook, projections, to come up with the fair value of the company? So they'll look at all that, but often enough they will say, you paid too much, and they don't always tell you why, but they'll say you paid too much, and we think you have a violation of ERISA.
So often, I mean, when I look at that issue, and again, I'm trying to make sure everybody keeps on track with this, because some people are like so branded to ESOPs. Some of the things that you're talking about, Wayne, too, are just, they dictate, because of the process that you're talking about, you have to have an arm's length transaction. It has to be a real negotiation. Right. They inadvertently dictate the way a transaction should be put together. So if an ESOP transaction is put together the correct way, which is you're going to have a trustee, like what Wayne does, who hires an independent valuation firm on the buy side. And then you're going to, you as the selling shareholder are going to hire your own advisor to help you walk through what you're going to negotiate on your side. Then you're going to have an arm's length transaction. So keeping that in mind, that's going to help support if the Department of Labor ever looked at it, that's going to help support that the actual value that was negotiated was what Wayne had referred to as adequate consideration, that the trustee paid what was a fair market value for the company. So partly, as you talk about that, I want to kind of point out to people as they're listening, should people be worried when we talk about the government investigating your company? I mean, that's going to throw some flags up for some people. Should people be worried about that in a normal ESOP transaction?
No, as long as you follow what we call a prudent process, where you have a detailed evaluation of the company's financial background, its circumstances, its management, its competition, its outlook for future profitability. Is it a sound company? The question is, should you invest in this company? Should we, a trustee, invest in this company for a pension plan for the participants? So they look at our process and they want to make sure that we have made we call it due diligence. So we're a buyer. Did we do the due diligence? Just like any mergers and acquisition transaction, the buyer should dig into the company and make sure they understand it, or they decide how much they're going to pay for it. What are the risks? Are there lawsuits? Are there chances of losing business? What are the likelihood that your management can continue what it's doing? So they want to see that we've done a detailed process and detailed examination of that. We've interviewed people, we've looked into things, we've evaluated their financial statements. So they want to see that we've done that. So we should have a pretty good record of that.
Absolutely.
And so
that's the point of this podcast, is to help people understand, like, if you're following what we're talking about, doing the process this way, then the confidence in that is that you're not going to have to be looking over your shoulder, saying, oh no, Does it mean you won't ever be investigated? No, but it will
No.
mean that if you do get investigated, you should have a high degree of confidence that you're going to be absolutely fine.
Right. And so when the trustee, a knowledgeable trustee, it's good to have an independent trustee. You definitely have to have an independent financial advisor, and someone who is experienced in conducting this process and documenting it, so they can show the DOL that it was done prudently, that it was done thoroughly, and that we have good documentation. If you don't have good documentation, they'll say you didn't do it. So we in our community, we take great pains to investigate things and to document it. So a lot of the money you spend with a trustee and a financial advisor, which may seem like a lot of money, but it's for us to do the work and to document this process, so that one, we've done a right job for the participants, that we didn't pay too much, we got a fair valuation, and the other one, that we negotiated a price that we didn't pay absolutely top dollar, and finally, that we are prepared to demonstrate that process to the DOL when they investigate. So we feel confident that we can defend our transaction, our process, our price. So you shouldn't be worried that you've got a problem just because you did an ESOP.
Absolutely.
Nevertheless, the DOL does investigate, and then sometimes, they're a little bit self-serving. They like to say, well, we didn't like the way it turned out. We didn't like the way the price turned out. We didn't think you relied on the appraiser properly, that your appraiser maybe wasn't qualified enough, or you just paid too much. Sometimes they'll tell you why. Sometimes they'll just say you paid too much. And then now you're crossways with the DOL, right?
Yeah. So let's get into some. I know you have some case studies. Let's break that out a little bit to get some more examples for people to think about how it would actually work. So I know you sent me one recently that you were looking at. Can you describe the kind of the overview of the DOL case that you were part of, or you were?
Yeah. So in this case, we had a large company that had already had an ESOP in place, and it was a successful company, and it was making good profits. The profitability of the company, and looking back, entirely justified the price they paid. And what they had was some key shareholders in the company retired, and when they retired, they sold some of their stock to other shareholders. So it was 40%. They brought the company from like a 20% ESOP to a 45% ESOP owned in a second transaction. And in that process, they sold some of the stock to the ESOP and some of the stock to other shareholders, and they all got the same price that we used that the trustees in that case and the financial advisor used for the negotiating the price for the ESOP transaction. Now, then they sold the stock. The stock that was sold to the ESOP was sold on notes, and the notes had a 9% interest rate, and they had a price that we determined was fair. The DOL in that investigation, first thing you got to keep in mind is it's like a 3-year investigation process. Okay, the DOL takes its time, and when they come to you, they usually come to you, and there's a statute of limitations. 3 years, the first statute of limitations. 6 years is the second statute of limitations. So when they come to you and they're close to that 3-year statute of limitations, the first thing they give you, along with their request for documentation and information, is a request that you extend the statute of limitations during their investigation, so it won't foreclose their ability to exact concessions or to change something. So the first thing they want you to do is sign a extension of the statute.
So going into, like, if it's 2022 right now, they can audit all the way, or they can investigate all the way back to 21, 20, 19, right? So right now it's a 3-year statute to 19. So then why would you agree to extend the statute of limitations? Or do you have to?
You don't have to, but there's consequences if you don't. So the first reason, the DOL needs time to conduct its investigation. And so one of the thoughts is we really ought to give them time to conduct their own prudent investigation and look into things. If you don't agree to the statute extension, The DOL only has two remedies. They've only got two things they can do. They can go away, and they're the 800-pound gorilla, and they don't tend to go away.
Right.
And the other thing they can do is file a lawsuit.
Oh, geez.
And they'll file a lawsuit and say, you violated ERISA, your transaction price was too high, it's a prohibited transaction, and what are you going to do about it? Well, that's not a good position to be in. And if they sue you, here's the thing. If they sue you, you get a new batch of people you're dealing with. It's the litigators. If you extend the statute, you're dealing with the investigators.
Got it. Better people.
So what I've done and what these people did in this case is they continued the dance with the DOL. They signed the statute extension and continued the investigation, and their trustees, their counsel, their financial advisors all pretty much opened the books and showed them everything they did. And I'll call it dance with the DOL until they're done with their investigation. and the DOL could come back and say, you violated ERISA, and we want you to come up with a remedy. In that case, you still want to dance with the DOL and work out a remedy, because if you go to a lawsuit, they just try to win, and that's very expensive. And at the end of the day, somebody loses, and it can be, you can win your case or you can lose, and the consequences are pretty harsh in that case. Sure. So what these people did is they danced with the DOL. This is a case where I'm involved with this company because they're now, several years later, selling the whole company for 14.5 times earnings, which is way more than the price that they ever paid for the stock.
That's awesome.
Stock price like 6 times earnings way back in 2009 when they did this transaction. So 2009 transaction. Wow. Well, keep in mind, they just recently concluded the DOL investigation not too long ago, about a year ago. Okay. And so when I was doing my due diligence to get in as a trustee for the sale of the whole company, they said, wow, we just finished up with the DOL, and it was almost 5 years that we danced with the DOL. And they came to us over and over again, more than at least 3 times, to continue to extend the statute of limitations. And they did. They extended the statute of limitations. And at the end of the day, this was one of those surprising cases, because we often hear these horror stories about the DOL hammering companies or suing them or finding a violation of ERISA and saying you had a prohibited transaction. What the DOL did in this case is they finally sent a closing letter. After 3 extensions of the statute and almost 5 years of investigation, the DOL finally decided these were the good guys. That's what you want them to know. You want them to know you're the good guys. You got nothing to hide. And you showed them everything and you justified it. And the DOL in their closing letter said, while we don't agree with everything you told us, particularly, we don't agree that you prudently relied on the appraisers for the valuation of the company. And we don't agree that the price you paid was entirely correct. And we don't agree that the 9% interest rate you charged on the ESOP note was fair at the time. We are going to take no action because you've changed your processes on how you pick and select an appraiser and how you would deal with a note going forward. I mean, they actually just resolved all this and decided these were the good guys and that they've improved their process for new and future transactions. In other words, the DOL wanted the ESOP to be healthy. They wanted the company to be in a position where it might sell more stock to the ESOP, and that you've corrected your way you do it. Now, I'm not saying there was anything wrong with the way they did it, but at the end of the day, the DOL wouldn't admit that there wasn't, but they said we're taking no action.
Right, which is like
and
great news. Let me ask you.
It's great news.
Yeah. So real logistically, they get the investigation. Who for the company is handling the investigation? Is it the company's attorney? Is it the company's trustee? Who's involved in managing through the investigation?
Interestingly, it's the company as the sponsor. They go to the company first, and the company then will usually engage their, what we call ERISA counsel, their ESOP counsel, the people that are knowledgeable and understand these DOL processes, to handle the investigation. and make sure the DOL gets all the things it wants, and that they get good explanations. The trustee doesn't run the investigation, but the trustee has to respond to it, and because they interview the trustee, and they'll look at the appraisal and ask, how you handle it and what you did, and they'll look at the negotiation process. But interestingly, the trustee doesn't run it. The trustee might be liable for this transaction.
They don't.
The trustee doesn't run it, but sometimes the trustee does have a lot to say, because it's their insurance and their concerns about it. The trustee also has to sign, all the parties have to sign this extension of the statute. So what, in my experience, we've had cases where some of the cases that make the news, that make the case law, where there've been tough results in a DOL lawsuit, happened because the trustee or the company refused to extend the statute and said, our lawyers tell us we don't need to extend the statute anymore. We think you are off base DOL. We don't agree with any of your conclusions, and we're just not going to extend the statute anymore. And boom, the DOL's got one thing, it's got a hammer, it files a lawsuit. Now you're in the soup. So my recommendation is to dance with the DOL, show them that you're the good guys and that you got nothing to hide, and explain what you did and why you did it. And then if they come up with something they want corrected, you negotiate the correction, as opposed to do it through a lawsuit.
Yeah, you're going to be better off. Like in this case, so specifically, there was a few things they found, but then they ended up just saying, hey, just keep going, don't worry about it. They didn't even have any damages, right?
They had no damages, no correction, no revision of the transaction. All of those things happen sometimes. And I'm not saying you should worry about that, but this was one of those clear cases where there's three things in that letter. Any one of the three things that the DOL disagreed with, I have often seen when we look at the lawsuits, were the exact same wording that they used in the lawsuit to say you had a prohibited transaction and you violated ERISA and you breached your fiduciary duty, and we want a lot of money back for the ESOP. So here was a case where they danced with the DOL, they showed them they were the good guys. The DOL finally satisfied themselves that they did not, this was not an ESOP that they wanted to hurt, or there were no players in this transaction that were
they didn't need a pound of flesh to justify.
They didn't need a pound of flesh. They didn't need to hang anybody up, prove they're the bad guys, or restrain them from being ESOP trustees or appraisers. And so they literally just said these three things that frequently could come out as a violation of ERISA. Well, they said they were violations, but would result in a prohibited transaction. They didn't do that. They said go and sin no more. Yeah. So that was a validation of something that I've run into in my practice, where I've had DOL investigations of my own, not of my, where I was not as one as a trustee and one as a quarterback when I used to do quarterback work like you do, where we just danced with the DOL, showed them everything they want, and we ended up with no bad result.
Yeah.
And I've heard over and over again from some trustees, some lawyers will say, tell the DOL to take a hike, and we end up in a lawsuit. And I'm concerned that that's just a way to make more money.
That's kind of where, like, underneath all of this, I'm thinking to myself, okay, first off, who is your ERISA counsel? Because they're the ones that you're probably going to guide you. And so typically the company's going to go right back to the ERISA counsel that put the ESOP transaction together. Is that kind of true, or is that? Okay.
It's common, yeah, but sometimes they'll go get litigation counsel that's used to handling litigation,
right?
And
which is a different department than the transaction guys, anyways.
Well, it's lawyers who make their money handling litigation. Okay, so
I think that's your car beeping.
Yeah, I had to start it back again.
Okay, no problem.
It'll only run so long, and then I had to crank it back up because I'm out here in the sun and the air conditioner has to work.
Yeah,
but if you're in one of these situations and someone's advising you to not extend the statute, you need to get
that's great advice.
Get a second opinion. Because the reason I say that is, would you rather have a judge or a jury decide how much you're going to pay to the DOL or would you rather negotiate your way through this transaction correction, even if they ask for one?
Yeah.
Well, because
yeah, I mean, so kind of intuitively, let me say it this way, because I don't know if this is true or not. I mean, if you're an ERISA attorney, I'm just going to say this, and it's probably just not a good thing to say, but if the ERISA attorney is going to stand to make a lot of money on a lawsuit versus I'm just going to
a litigation counsel,
yeah, versus I'm just going to kind of help a 3-year investigation go through the process.
right.
Would that motivate them to give their clients the wrong advice? Or I know it's not going to.
I'm not going to say that, but you can read between the lines.
I know.
Whenever you lock it up, whenever you tell the DOL to take a hike, they're not going to do that.
No, that's not going to happen.
And when you refuse to extend the statute, like I said, they either have to go away or sue you, and they sue. So now you're in the soup, and what does it cost? I had a case where the DOL said you paid too much, and we want this transaction corrected. And I handled that transaction as a quarterback, and the trustee in that case was happy for me to handle it because we opened the books, we were the good guys. And when the DOL said they wanted a correction to the transaction, I was able to get with the Dallas regional office of the DOL and ask the investigator, what do you have in mind?
Mm-hmm.
And they said that we had, a great big note that the company was a 2008 transaction. The economy went to pieces after that. The company really lost value and they weren't able to pay this note. And the DOL said, the ESOP's never going to be out from under this note. We'd like to see that go away. So we restructured the transaction where the seller took back majority interest in the company in exchange for eliminating part of the note. And then we still had an ESOP, but it was a partial ESOP, and no penalties, no fines, and they approved it. And then we had to restructure the transaction, but it cost about $30,000 in legal and accounting fees for a 2-year process. Very reasonable.
Yeah, that's
for a result where the seller said, well, if I had to take back some stock, I wasn't getting paid on my note anyway.
Yeah.
That's a lot better result than having the DOL come in and pop me in a lawsuit for $2 or $3 or $4 million of damages to the ESOP. Plus the litigation cost would have been easily $1 million. Easily.
Yeah, that's what I was wondering. Like, what would it cost to defend in a lawsuit? It's about $1 million, right? I mean,
it can easily be that.
The way
because now,
time,
go ahead.
Yeah, the time that it's going to take, because you're dealing with the government in a lawsuit, you're going to go back and forth, and the attorney fees are just going to be cranking up for all of that.
And where do they come from? The attorney's fees in the initial stages of that, once it starts as a lawsuit, all the information that you exchange back and forth with the DOL is in what we call discovery and subpoenas, okay? And the lawyers handle every piece of paper and they deal with it. It costs hundreds of thousands of dollars to go through the information exchange to get ready for the lawsuit, when we just handled it. We handled it directly with the DOL, gave them everything they wanted to know, because they're going to get it anyway. There's nothing they're not going to get.
Well,
so instead of it costing.
Yeah. And the worst part about this thing that gets me going is it hurts the ESOP, right? Because where all this money comes from, because it hurts the employees, right? The Department of Labor is there to try to help them.
If they have to lower the hammer, the company's hurt, the sellers are hurt. It takes a lot. How much does it take out of the management team to deal with a lawsuit?
It's
really devastating.
Yeah, I think this is such a good podcast, Wayne, because I'm telling you, these are critical decisions. They are important. And I think every good business person has to always in their business career make a decision like, do I sue or do I settle, right? And I think most every single time I've been in that situation, I'm like, it just doesn't make sense to try to go after a lawsuit.
Let's resolve it. Let's resolve it through a negotiation. And so I also talk with frequently some people who regularly deal with the DOL and their investigation department, and am told that most of the DOL, they just want to make sure there's a square deal and a fair deal for the ESOP, and just show us. And and maybe they come out with a contrary opinion, but you can always resolve even a determination by the DOL that you had a prohibited transaction. They want to see something corrected. You can correct it a lot cheaper with a negotiation than you can with a lawsuit.
Yeah, I think the big thing I wrote down was just, why would you ever go after? Why would you ever want to engage in a lawsuit with the Department of Labor?
Why pick a fight with an 800-pound gorilla? Yeah,
it's because your ego, like you're egotistic. You're thinking, oh, I'm whatever. That would never make any sense, right? I mean, would there ever be a reason to go?
I don't think so. I mean, I really don't. I don't think so. So
yeah, I don't either. Financially.
But anyway, so what we're saying is, how do you bulletproof yourself in an ESOP transaction? The things we said at the beginning of this podcast is do it right.
Mm-hmm.
Have a fair valuation, document it, have your professionals that are working on the trustee side, make sure they have a reputation and an ability to do it right and document it, and have a real negotiation. They like to see a real negotiation. And then if the DOL investigates and comes up with extend the statute and then work it through with negotiation. Make the lawsuit the last thing that they need to do. Don't make them do it.
Yeah, don't make them do it. Do you know, like, just in general within the ESOP community, how many percentage-wise, how many ERISA attorneys are dedicated to litigation versus how many are doing transactions? Do you have an idea of that? I mean, I know we're all part of the same ESOP community, but I'm just curious because it's
well, I will say this. I don't know the percentage, but a lot of the top law firms do handle the litigation, along with handling ESOPs. But most of the litigators don't form ESOPs. Okay, they come in and help litigate, and they get hired when the DOL comes in to investigate. And people go, well, we want to get the best lawyers we can. My suggestion is make sure that the lawyer you get to handle this and advise you is not leaning towards triggering a lawsuit.
I think that's the key. Like, we keep hitting the nail down on the head there. It's like, yeah, make sure. I mean, I always want to try to give people good advice, and it's hard to say, all right, every situation, it's going to depend. And that's always going to be something everybody's going to say. And it's true. But I guess the biggest advice here is if they're leading down the trail of going into a lawsuit with the Department of Labor, and there's a very, a modest way out with like Wayne says, dance with the DOL, which I love that. I'm gonna title this "Dance with the DOL." So
better dance with the DOL.
Dance with the DOL, because I'm 30 grand over 2 to 3 years versus, $1 million plus the potential of paying out.
And it may be a lot more than that to resolve the DOL to resolve it with dance with the DOL. But I promise you, you will not even believe how much it costs when you go through litigation. And the other bad part is, if you do the litigation, you're going to have insurance. Let's say insurance, your ERISA insurance, fiduciary insurance is going to cover a lot of this, and your D&O insurance is going to cover a lot of this. But what happens? The insurance company is putting out a couple of $1 million on this defense, and maybe even more on the settlement. And what do they want to do? They don't want to write insurance for it, or the rates go up. So this came up for me in my career, because we're having one of the biggest challenges is getting adequate insurance and reasonably priced insurance for fiduciary and board of directors insurance. And so I started asking the insurance companies, what the deal was, and they said, well, we have so many claims. Or no, we don't have so many claims. We have a few big claims. And then I talked to the people who were involved in the litigation on the big claims. And I tell you that over half of them that I've talked to, the thing that triggered the lawsuit was the refusal to a finals day when they refused to extend the statute.
Wow.
I'm not saying the DOL won't sue right out off the bat, or they won't sue anyway, but they usually don't. And in some notorious cases that, Phil, about, we go to the ESOP Association, we read these cases, and you go to the players in it, and I said, what happened? And they said, well, our lawyers told us not to extend the statute, and we didn't. And so the next thing we know, we were in this lawsuit.
Wow. Can it be just that simple, right? Just
Well,
pull it off,
you
right?
know, it's
You
not
know?
rocket science. You know, this
No,
is,
it's not. But I think
and
part
if
of,
you,
like I said, ego, and then people are smart people. The ESOP world is full of smart people, and so it's convincing when they say, "No, we have a good case," and this is why. Boom, boom, boom. And I think that any good ESOP transaction, every one of a good transaction, you're going to have a good case. But the bottom line is, why would you want to go into a lawsuit and spend that kind of money when you can just go through the motions with the Department of Labor and deal with it step by step?
and once you get in a lawsuit, the fundamental result of that lawsuit is out of your hands. It's 2/3 out of your hands. If they go to a trial, you'll get a judgment. Either you win, and a lot of times the sellers could lose and be hit for some significant damages, and so it's not, you get to just adjust your purchase price. Let's say in the case where we exchanged a note for some stock, no pain really. I mean, we revised the transaction, but if the DOL had sued and said you paid $8 million too much for this stock, they would have hit the seller for an $8 million in damages.
Yeah. On top
And
of
then now you got a damage judgment.
Yeah.
And you hadn't even been paid your $8 million on the note yet. So I'm not trying to scare anybody when I say that. I'm saying,
of course not. Yeah. Don't go into a lawsuit. Yeah.
So you got a bears come to your camp. If you can give the bear what it wants and it's not your leg, you may be okay. You can give it your lunchbox, or you can redo it like A1. The other thing is to recognize a lot of the noise in the ESOP Association legal community is the DOL is just a big predator that's after ESOPs. So I wanted you to know I don't believe that's the case. In my experience, in dealing with the DOL, they really are, for the most part, just trying to get a fair transaction for the ESOP, and they're willing to work it out.
And that's their job, right? When you get down to
it, their job. That's their job.
They exist for a purpose, and I agree too. I think it gets talked about like, hey, they're the enemy. They're the checks and balances between a good ESOP community.
We're glad they're there.
Yeah, we are glad.
I mean, because years ago there might have been some cowboys out there that just did ESOPs any old way they wanted to. Now, if you deal with advisors who are members of the ESOP Association, the NCEO, who regularly maintain ongoing continuing education, who come together to work on best practices and exchange stories and knowledge about this, we work hard to do it right. And so get good advisors, make sure it's well documented. And I know if you're working with Phil, I've worked with you, Phil, on transactions. You set them up very well to start with. You help explain to your clients that, yep, we're going to do a lot of work on this due diligence and on this valuation work. And then we're going to have a negotiation that is going to result in a price that might not be exactly what the seller wanted in the top dollar, but we're going to come out with a seller price that the seller is satisfied with if they want to do the deal, and that we believe is defensible.
The seller can sleep at night, and then everybody else can win at the end of the day.
And then we've got it documented. And if the DOL comes to investigate, we're going to immediately build a reputation with the DOL that we're the good guys. We got nothing to hide.
Let me ask you a quick question as we finish. What if the trustee wants to do the lawsuit, but the company doesn't, or vice versa? Because it sounds like you have to have a collaboration between the trustee and the board of directors going into the investigation. Is that
it's possible, but it's not likely, unless because at that point in the investigation stage, there's almost no way for the DOL to be saying, we want to hit this trustee with big damages.
Right. Okay.
You don't have that going on in the investigation stage and in the resolution stage.
Yeah.
It could be, I don't know, you got to be careful some trustees, if trustees have been in a lot of lawsuits or they've been in a lot of problems, you want to make sure they haven't had a lot of those where the DOL is after them. But
Yeah,
the ones that the DOL, I was going to say the ones that the DOL is really after, they've already gotten an injunction to say that those people can't serve as a trustee going forward.
yeah. And it
So
might
there's not too
be
many of those left.
it might not be a bad question when you interview a trustee. Hey, how many lawsuits have you been involved in? I mean, that's
Well, and how, or investigations, and how did
Yeah,
you
or
resolve them?
investigation.
How they turn out?
Yeah, just to give us the process of what you've gone through.
Yeah.
And yeah, so I think that's a very valuable thing to know. And I think as Wayne and I finished the topic, it's like we want to make sure we started with this and we finished with this, is that the ESOP transaction is not risky from a Department of Labor standpoint, and it's because of what we're just talking about.
If you handle it right, yeah.
But you handle it right, and that the point of this conversation is to help you make sure you handle it correctly, and that you're getting good advice going into it, and not bad advice.
But and that's what one of the big challenges people who are thinking about doing an ESOP have is, how much of this is out of my control? What am I getting into? It's not out of your control if you know these things, you work with good advisors, and you keep this in mind. Where they fear is that the DOL is going to come in and do something to them, and they don't have anything to say about it, and they're just stuck. Don't let yourself. You don't have to be in that spot.
No,
And you can manage the process if something does come up.
Yep.
And so this happens with business owners all the time. Somebody sues you for some crazy reason, right? What do you do about it? You negotiate, you resolve it, you settle, you try to stay out of a lawsuit. You manage these things.
You may not like it, but you just do it. You just it's part of business. It's part of what happens.
It doesn't have to have an outsized impact.
No, exactly. So, well, great. I think this was very, very helpful. Thank you so much, Wayne, for
you bet
chiming in on a really important topic. And as always, we just appreciate everybody checking out our podcast. And with that, we'll sign off. Thank you for listening, and we'll see you on our next step on this journey to an ESOP.